Welcome to another episode of Keeping Employment Law Simple. My name is Edward.
And I'm Emily.
And together, we are the hosts of this channel. We'll be right back, so stay tuned. Today, we're going to talk about a selected case on stress and mental ill health in the workplace, providing a summary of the decision and implications for employers. The case in question is Harry versus Dudley Metropolitan Borough Council. The issue of the case is centered on stress and disability protections.
The facts. The claimant was a design and technology teacher who was also a part-time youth worker, was continuously absent from work for over 4 years. The reasons for his absences for half of that time related to physical injuries, including a fractured ankle, post-operative recovery, leg and ankle pain, and stress. For the second half of the absence period, the reasons changed from more physical to more mental aspects, including work-related stress and anxiety.
An occupational health report stated that, from a medical point of view, he was physically and mentally fit for work and could return to work as soon as possible, but that there were management issues at the workplace causing stress.
The teacher was eventually dismissed for gross misconduct. He made numerous tribunal claims containing over 90 allegations, ranging from sex and race discrimination, harassment, and victimisation. Most claims were dismissed, but the remaining claims included direct disability discrimination, a failure to make reasonable adjustments, disability-related harassment, victimisation, unfair and wrongful dismissal.
Now the decision, this is very, very important. The Employment Appeal Tribunal had to decide whether the teacher was disabled. There was little or no evidence that his stress had any effect on his ability to carry out normal day-to-day activities. The stress was largely due to unhappiness at perceived unfair treatment and therefore was more of a reaction to life events. There was a distinction between a mental impairment, which is protected under the Equality Act 2010 and is capable of being a disability, and a reaction to life events, which is not protected. The evidence that stress had an adverse effect on his ability to carry out day-to-day activities was insufficient, other than it had an occasional impact on his dyslexia. The Employment Appeal Tribunal confirmed that the teacher was not disabled, so the disability discrimination claim failed.
Stress alone is therefore unlikely to be classed as a disability. The Employment Appeal Tribunal provided useful guidance on when workplace stress may amount to a disability, issues to consider when awarding costs against a claimant who can't pay but may be able to in the future.
In the light of the many allegations, the teacher was found to be unreasonable in pursuing his claim and was ordered to pay the employer's costs. He had ignored cost warnings in the lengthy case, and he unreasonably refused to accept the explanations for the acts he complained of.
Implications for employers. Under the Equality Act, disabilities are physical or mental impairments that have a substantial and long-term adverse effect on an employee's ability to carry out day-to-day activities.
Mental health issues are an increasing factor in sickness absence and are a predominant cause of taking time off for illness, but not all types of mental issues, including stress itself, are a disability. Even if an employee has a very long period of time off work, this does not mean that there is a mental impairment amounting to a disability for the purpose of the Act.
The court said there was a distinction between two conditions with similar symptoms: a mental illness or clinical depression, which is impairment under the Act, and similar symptoms which are not a mental health condition but simply a reaction to adverse life events, such as problems at work.
Now, this case contains some further guidance. Employers may be tempted to think that stress cases are not a disability. However, employers should be cautious when deciding if an employee suffering from workplace stress is disabled and should obtain occupational health and other medical reports to help provide an informed decision about whether employees are disabled.
In this case, the occupational health report had said the employee was physically and mentally fit for work, and there was little or no evidence that his condition had any impact on his day-to-day activities. But in other cases, there may be more evidence that it did have an impact.
Being unhappy with decisions made by an employer, having a grievance against a colleague, or refusing to compromise at work are not mental impairments. However, employees with evidence of ways in which their life has been impacted may have work-related stress disability discrimination claims. If an employee provides evidence to demonstrate a substantial adverse effect on their day-to-day activities and can show that this has lasted or will last for 12 months, then the definition of disability will be met. And this, viewers, brings us to the end of this video. Now, if you're looking for professional advice and guidance, you can contact us on
hubteam@hrhubplus.com
or 0333 577 0788. Thanks for watching, and don't forget to hit the subscribe button.